Did you bring your pay stub? Did you bring the utility bill?
Morning.
Good morning, Your Honor. Morning.
My name is Courtmaster White, and we're going to begin by having
Okay.
parties please stand and raise their right hands to be sworn in.
Do you solemnly swear that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, please be seated. Appearances, please.
Yes, good morning, Karen Sternlick, representing applicant Teresa Pena, who is seated to my right. We need to put this stuff
Good morning,
away.
Your Honor. Mark Beglin, present with the adverse party. I'm not aware of the members in the gallery. If there's going to be anyone potentially to testify, we would invoke exclusion.
Certainly. I can recognize 2 out of the 5, so
Oh, please.
everybody else, well, ma'am in the back between the deputy, and are you with
Bring the
the...
pay stub.
Yeah, I'm Tracy here.
All right, so you'll stay. Ma'am in the back, your name, please?
Victoria Fitzgerald.
Victoria Fitzgerald. And what relationship do you have to this case?
I'm Teresa Penna's daughter.
And is there a chance that you might be called as a witness,
No,
Okay.
Your Honor, we're not calling her as a witness.
Mr. Beglin?
Fair enough. We have a non-witness also, Your Honor.
All right.
My client's son.
All right. And this is case TPO 1700540. This is a time and place set to determine if the order of protection is going to be extended. There was a criminal arrest, correct? Criminal charges are...
Yes, Your Honor.
Yes, Your Honor, there is. I will, for the candor to the tribunal in Reno Justice Court, there is a matter, 2 criminal charges involving the applicant, and then the parallel case, which is, we believe, the daughter of the applicant.
Correct.
Both of those matters are proceeding in the Justice Court, and the arraignment is on April 20th.
All right. Thank you, Mr. Beglin. Mr. Erlich?
And
Oh, go ahead.
if I may, Your Honor, perhaps maybe a point of judicial economy, also a point of policy. We can spend some time doing the line by line, he said, she said, perhaps, in the application. At the end of that process, if there is still pending criminal charges in a different court, would this court be more inclined to, as a policy matter or safety, to keep this order in place? Or is there a realistic vision that this matter could be dissolved and the criminal case proceed on its own independently?
Well, we've done that occasionally, but that's usually been on agreement from the other party and the other counsel. Typically, if that's not the case, if there's not an agreement, then we'd simply continue. Often, your client would not say anything because of criminal charges and be extended. So, Ms. Sternlick, would you be inclined to dissolve today's order so that and allow the criminal case to be the only case?
And Your Honor, with the court's permission, may I remain seated?
Certainly.
Okay, thank you. No, we're not agreeing to that. We are requesting that we go forward today based on Ms. Pena's application for a protection order and her request to extend it.
Well, Mr. Beglin, we don't have an agreement from the other side, so typically we go forward, and typically clients on that side of the room don't testify at all, and it's extended. And once the criminal matter is resolved, certainly you can take your cues from that, however it works out.
We
Yes,
do
Your
have,
Honor.
if I may also, Your Honor, for not trying to be out of line. Good morning, Ms.
Certainly.
Sterling.
Good morning, Mr. Beglin.
And if the court, at the end of this process, is inclined to extend it for whatever basis, there are some matters of some property questions. This is a 1-year marriage. My client's home, he's been in for 20-plus years. He's now excluded from that. There's some items that he'd like to get until this matter is resolved, the criminal case is resolved, and ultimately, it looks like we're destined for the 3rd floor for a divorce court as well. Does this court entertain requests for return of, I know the TPO order says he can get his toothbrush and medicines. He'd still like to do that, but there's some other items that we can talk more specifically.
We can work that out. That's not a
Okay,
problem.
thank you.
That's no problem. Ms. Sternlicht, did you want to
Thank you.
add anything to that?
Yes, Your Honor. I just want to be clear that we are requesting at this juncture, and I just want to be clear, I do not represent Ms. Pena's daughter, Tiffany Carter. However, I believe her testimony and her application corroborates what's in my client's application as well. I'm sure counsel can also work that out. My understanding is the parties have been married for 20 years, not 1 year. They never did get a divorce, but again, I'm not in the divorce case, so I can't really speak to that. There are property issues. There is a marital home that my client is in right now. That is part of our request, that she be allowed to remain there, at least until this, it could always be modified by a divorce, by a court on the third floor. And we're also asking that certain financial issues get addressed as well. Thank you, Your Honor.
Let me skip to the end. We've got two, at least one in this case, a criminal arrest and domestic violence. All right. Typically, that finding, until that's resolved fully, is enough to extend an order, because my level of proof in this case is satisfaction of the court, which is really low. And so typically, this side doesn't even put up, I don't say fight, but they're more interested in what that means as far as returning property, getting property. So I'm not inclined to spend all morning when we have this arrest that we're waiting criminal charges on, which frankly he shouldn't speak of anyway. So he can't talk. We've got this arrest. We've got this criminal charge. So it'd be silly to waste our time that way. That being said, I did a little bit of research on this case, and it was very interesting. Not this case, but the related divorce. Almost 20 years ago, the two of you went through divorce proceedings, had good attorneys on both sides. I believe the applicant was represented by Mr. Stone. He's a seasoned attorney, and frankly, I don't even know if he's alive anymore. All right. So here's what happened. They had a trial in front of Judge Schumacher, put on their cases, went to the mat, so to speak. Judge Schumacher proclaimed, here's the order, A, B, C, and D. And counsel, Mr. Stone, who I don't even know is alive, you prepare the order. Okay. Mr. Stone did that, as he was instructed. Then, both parties get a copy of a letter from Judge Schumacher's law clerk, dated December 7th. Dear Mr. Stone, and they put Mr. Pena, but I'm sure it's
Mary Bosch.
yeah. This letter is unable to grant. This court is unable to grant this divorce pursuant to NRS 125-130. Every decree of divorce must contain the Social Security number of both parties. This information is not in the proposed decree. Please revise the decree and refile it along with a new request for submission with the clerk of the court. If you have any questions or concerns, call me at blah blah blah, law clerk to the Honorable Deborah Schumacher.
And it
Yeah.
was,
Talk about
I never got the letter.
freight train out of town, Your Honor. Your Honor gets quicker papers than I do. We're still waiting for our document request.
Yeah.
It's so old, you can't view it in real time.
exactly.
But this is an interesting question for Nevada law, because it has deep, deep ramifications. The parties believed they were divorced. They thought they were divorced. They acted as if they were divorced. They didn't live together for 19 years.
She remarried?
Hold on, please.
Sorry.
And the applicant, in fact, remarried, and there was a probate of her interim husband's estate. There was assets that were transferred. Then our parties hook up about a year ago and get married. And they thought they were getting remarried, but they've been married the whole time, filing separate tax returns, the interim marriage. This sounds like a law school exam.
It does.
With all the magnitude of potential spin-off issues. So we're hoping that if these parties are in fact still married under the eyes of the law, and our case law tells us either married or not, they've been married since way back when, that has a huge mess as far as unwinding what's a community asset, what's not. There's presumptions, there's equity, there's compelling reasons to do whatever the divorce court thinks is appropriate. But we find ourselves in this unique circumstance. So that's why the recent marriage, about a year ago, we believe is void ab initio, because they can't get married twice. You can't marry your spouse twice, unless it's a ceremony where we affirm our vows kind of thing.
Sure. So let me throw one more curveball. The story gets even better. and I can't determine who did it, and I suppose if I did some research I could, but in October of last year,
Of 2016?
2016, somebody, and I don't know which one it was. I have my guesses based on what the documents had in them. But in October 2016, somebody in that divorce case files the plaintiff's trial statement, the defendant's trial statement, and also a copy of a quitclaim deed from her to him with the house. Just files it.
Well,
Just
that was
there.
done because of, just for the court's information, it was done, the house was originally, because I went and looked at the Washoe County Assessors, originally the house was in Mr. Pena's name with his mother. And then it was, I think his mother passed away, and so he went on title, but he also refinanced, and as part of the refinance, the title company required her to sign something. So just for the court's information, she's not on the title, which of course doesn't mean that she doesn't have some, God knows what it is, but some community property interest in the house. But apparently, from what I could gather, speaking to Ms. Pena and looking at the assessor, I think that was required because they were married, at least the title company, that's how they viewed them. And so they, because of community property law, required her to sign something. The
Right.
house is still, at this juncture, is in Mr. Pena's name alone. He is the sole title, he's solely on title, and I believe she may or may not be on the loan, but she's not on the loan. You're not on the loan. Are you on the loan? The loan for the house, the mortgage?
I signed the papers.
Yeah, so they required her to sign something because of community property law.
Well, because of the intervening marriage, I was going to give you. I mean, you know this anyway, probably better than I do. But I was going to suggest to go back to 5 and say, can we have a nunc-pro-tunc order saying
Wow.
they're divorced from? But the interim
Yeah.
marriage, I don't know now. That's not going to probably be an option.
Well, and again, it's kind of like, I mean, to reiterate in a plain way what Mr. Biglin was saying, it's kind of like you can't be a little bit pregnant. So either they're married or they're not, which is what Mr. Biglin said, and he's correct. And so the reverse argument can be made that any subsequent marriage is void ab initio, and they're still married because you can only have one spouse. So on the law school exam paper, we can argue it from the other side too.
And then everybody that's in the probate, that's not her, suddenly has a cause to come forward, and
It's really,
it's.
I mean, right? I mean,
The
it's.
magnitude of liability is overwhelming.
It's huge.
Yep.
I mean, it's huge, and I mean, it's a good thing that neither one of them have died in the interim. I mean, the husband or the wife, because then you have more law school exam questions. I mean, but really, all kidding aside, I mean, there are a multitude of issues here. But you can only be married to one person at one time, and if they were never divorced, they're married.
Right.
Yeah.
That's not a quarrel, Your Honor. The quarrel is gonna come in to say,
What's
gee, we
good-
had these 18 years of intervening and no contact, we thought we went on our own lives. Applicant remarried somebody else and then was a survivor spouse. To then, I've faced questions like this before. It's been a couple years where high school sweethearts get married, one person's over divorced, you go on your own way, have new spouses, have children, then you realize that the divorce was never done. That's just a real mess to unwind, but it's not impossible.
No.
That's when the laws of equity apply. But
Sure.
we know about the house and this home in particular, Honor, which my clients lived there forever, pretty much, 21 years. In 2005, there was a deed transfer from his parents, Charles Sr. and his mom, to him. So that was the last time there was any activity in '05. Now, if there's a deed that's been recorded, something that Your Honor is speaking of, I've not seen it, but that would certainly be something
Yeah.
to fit into the puzzle. Do you have it?
Well, I don't have the actual deed, but it shows that the transfer was made, I assume Sharon was his mother, is that correct?
Yes.
Yeah, so it looks like it was transferred, right, in 2005 from Sharon and Charles Jr., which is your client, just to, I'm sorry, no, you're right, from Charles Sr. and Sharon in 2005 to your client. So it was done in 2005. It could also be argued that given that he represented to the title company that they were married, that's why she had to sign some kind of a waiver of her interest. So, I mean, that's another issue too, that he was aware that they were in some kind of a marriage. At this point, given that the issues are somewhat circumscribed before this court, we're arguing that they are married right now, that he has been arrested. I mean, there's certain facts that can't be refuted. He's been arrested on 2 counts of domestic battery, which are pending, one against my client and one against my client's daughter, who has a separate application here. And that there is a marital home that they've been living in, that my client is living in now, and that this court has the jurisdiction and the authority to grant her continuing possession of that home, which is what we're asking for right now. There are other related issues around vehicles and various things that they've acquired. Maybe, I could certainly say in the last 20 years, but certainly recently, including the car that she's driving, which is the Ford Expedition, the 1999 Ford Expedition, which is in her possession now. It is titled in Mr. Pena's name, but we are asking that she be allowed to continue to drive it. That the rest of this is gonna have to be sorted out, on the 3rd floor.
Last interesting point.
Yes, yes.
I see the last entry in the divorce, November 15th, 2016.
Oh,
Teresa Pena called for a pickup of a DVD.
and that was not me. I was not in the case then.
Okay.
Yes.
All right.
Did you get the DVD?
I have the DVD and I have a copy of the whole file.
Yeah,
All right.
Again, my representation, or Washoe Legal Services representation at this juncture is only limited to the domestic.
All right. And that's
Domestic
the
violence.
least exciting part of the whole thing. If you're a law nerd like the 3 of us obviously are. All right. So that being said, Ms. Sternlake.
Yes, Your Honor.
Well, actually, Mr. Balin, at this juncture, are you opposed to extending the order of protection and going over terms of what that would mean? Or would you like Ms. Sternlake to put on her case and have your client essentially not be able to say anything to it?
Well, Your Honor, that's kind of, may I be excused from rising?
Please sit, please.
I climbed a ladder all weekend, so my knee is thanking me. Thank you. We know that there's a constitutional right against self-incrimination.
Correct.
And if it comes to that, my client would invoke that privilege because of different cases going to take place on the 2nd floor. But just for the record, we would indicate that we absolutely dispute the characterization of what happened, and that to place the parties on notice, this will be argued as self-defense. So that's why my question was, given that circumstance, Your Honor, would be policy for judicial economy, would that ordinarily be the case where that would be enough to sustain an extension? And then the
Yeah.
question becomes, if so, and we respect that, and we expected that, for how long? We have a soon-to-be-filed divorce case, and we have a criminal case trending as well.
Typically between 6 months and a year, typically.
Okay, thank you for that.
All right.
My client, for purposes of this, again, which is baffling, there's this 20-year period of silence, and how we characterize property acquired during that time is interesting, because the statute tells us anything acquired, even by voluntarily absent spouses, is still presumed to be community, but it's a rebuttable presumption, and we believe we can do that. But there are some things in the home that my client, again, until just a year ago, he had been living there 20 years. You can imagine a lifetime of your possessions. Now you're out. We do know that this was a pressure cooker. There's 5 adults, the applicant, her adult children, my client's adult son, and him. So this is a pressure cooker of stress. But there are some items that he would like. He has a computer and a monitor that he would like. He has a shipping container that has items that he considers valuable. They're locked up, and he would like to either have a truck pick up that shipping container, which is locked. If the court's not inclined to do so, then we would like to have a locksmith there on deed site to install a new lock and seal it so that contents may not be disturbed. We don't want to have a repeat of when the parties were in this same situation in 1997. There was a TPO, an exclusion order, and then suddenly some of my client's property disappeared.
Everything.
We don't want that to be a problem. Alternatively, if Your Honor were to issue a reciprocal order that no community property could be damaged, destroyed, sold or given away as is authorized in a divorce statute to preserve the property status quo. We just don't want to have a yard sale this Saturday and out of spite, my clients' assets are just gone.
Yeah.
You know, there might already be an ex parte order
There is one that prevents
prohibiting
my
from
client.
1997 prohibiting either party from doing any of that.
Well, Your Honor, just to respond about the shipping container, and my understanding is, actually I have a picture of it, it's called a Connex. My client did locate the key to the shipping container. They both have had items, or they both had items of property in there. My client has just indicated to me that she found the key over the weekend, that she's removed her items. We would just ask for, is it that he wants to move the container, or is it that he just wants what's in the container, Mr. Beglin?
Both.
Okay. Why can't he just get his items out of the container?
These are heavy machine tooling, super heavy items that are valuable, and that container is the best location to store them. And it's a simple matter of a truck backing up to it, and they winch it
I
onto the
understand.
flatbed, and it drives away.
Well, my only concern is that given that there's gonna be an issue about what's community property or what's a community property interest, that there be some inventory done of what he's taking from that box, that Connex container, so that it could be reserved.
Of course. Your Honor, I'm not gonna argue.
Well, can I just finish? So that it could be preserved for whatever's gonna be argued upstairs, and I don't know, it may be that it's 100% his separate property, it may be that it's 50-50. I mean, who the heck knows at this point? But, I don't know how we would do an inventory if these are heavy, I mean, these aren't just like, a simple transmission pan, apparently these are heavy parts. They're not heavy parts.
They're parts for his car and some odds and ends. Other
Okay,
car
are you
parts.
able to take an inventory of what's in there, like with a video or with your smartphone?
Yeah.
Okay, so I'm gonna have her do that, and then I can make arrangements with Mr. Beglin for him to remove the container, if that's what he wants to do. But if my client is telling me the parts are not real heavy, maybe he wants to leave the container there and just take the items that are contained within it. I mean, the container is big, it's like a shipping container. I have a photo of it here.
Yeah, they're big.
Yeah, this is how big it is, Mr. Beglin.
Yeah, I know. I
Yeah.
deal with them every day.
Oh, okay, well, I don't. So, what I'm saying is maybe it would be easier for him to take what's contained in there and leave the actual container.
Are you done? I'm sorry.
Very valuable stuff. The only way I could,
Your Honor, my client has deep distrust. This happened when the case first started back in 1997. We had a restraining order, my client was out, things disappeared. We understand through counsel, she has asserted that her client has entered the container and has removed all of her items. So the conclusion would be that anything remaining is not in dispute. And my client can either, one, have the container just removed, or with the contents that, and the applicant's more than welcome and pleased to inventory it in some capacity. Also, I'm informed that there is a box van that is on the premises, that those items inside the container can be put in the box van and then driven away. But
Is
that
that
takes
the-
time and labor.
Is that the motor home? Is that what the box van is? I don't know what a box van is.
I'm getting a nod, yes.
He could take the motor home. It's not running. If he wants to, my understanding is it's not running. If he wants to remove that, again, we're not waiving that there's any potential community property interests, but we are at this point, we are willing to give him possession of the motor home. He also has a Harley Davidson in his possession. I believe there's also a four-wheel drive tracker that's on the property. Is that something that he wants?
Hold on. Your Honor, this is not a settlement conference for property division. This was just, we're asking for some emergent help
I understand.
to make
That's
sure
fine.
that things don't disappear.
I term cases, well, this case isn't quite there yet, but some cases I term them TPO divorce, because we don't want to do it in the divorce, not you folks, but we'd just like to do it here because it's so much easier. We're here immediately. And to that, I usually say no. If you need your tools, if your client needs his tools, to do his work, then the shipping container can be worked out. As far as
Fine.
moving an old, not running this or that, no, we're not going to get into that. That's what the divorce is for. That being said, it sounds like there's no objection to extending the order of protection based on the circumstances laid forth. There's a criminal trial coming, and his client's not able to or shouldn't put his testimony on the record because it could be used against him. That being said, the court's inclined to extend the order of protection for 6 months, not to come within 100 yards of the applicant's address. Also, not to have any contact with her, whether it's texting, calling, writing, or social media, or having other people talk to her on his behalf. And let's see.
I have no
There's a
problem.
related problem, Your Honor.
Oh, we'll get to it. There's lots of problems in this
Yes.
case.
I'm sorry.
This
Not
case
to
is just.
trivialize, but it has to do with the distance and the stay away order.
All right, talk about that. What's wrong with the?
As luck would have it, the parties work on Vista Boulevard and Sparks at adjacent warehouses. And so, every time my client drives in to go to work, he's in violation, and we
It
don't
is not
wanna-
a violation for purposes of this order for the adverse party to go to and from work. Period. We have that order.
Thank you.
Also, he's not to come within 100 yards of 475 Compton. And there are no animals.
There's a dog, Your
There
Honor.
are
Is there a dog?
two dogs, 3 cats.
Well, for purposes of our order, my order, about whether or not he can be around or take or harm, that provision wasn't made part of the order. And so if we're talking about more property division, that's again, divorce issues.
Do you have the dogs?
I have all the animals.
Okay.
And so,
Your Honor, there's, as I mentioned before, there is a 1999 Ford Expedition, which my client has, and we would ask that during, at least right now, unless there's some further orders from upstairs, that she be allowed to continue to have the possession of said vehicle.
let me turn to Mr. Beglin. Is that okay with your client? That
Your
she
Honor,
be-
that vehicle is my client's vehicle. He used it to
okay.
commute. And right when this fax went down, within days prior to that, there was a dispute over the ownership of the vehicle. So suddenly, a TPO occurs, there's an arrest made, circumstances got escalated. But that vehicle is registered and insured, and my client, he's had it all these years. He's using it,
That's not
he needs it
correct.
to get to work.
No, he has not
That's
been
not
using it.
correct.
I'm sorry, what?
This vehicle has been used exclusively
Okay.
by my client, and we're asking that, these parties are married, and we're asking that she be allowed to continue to use the vehicle. It's the only vehicle, she doesn't have access to another vehicle. She uses it to go to work, she uses it to go to all of her medical appointments, and it is the vehicle that she's been driving.
Is there another vehicle available for you, sir? There's only one car between the two of you.
No, they have
No.
other, he's using, he has a Harley-Davidson motorcycle, which he already has. And I believe he has another vehicle as well.
No, I
But he
don't.
has a Harley-Davidson vehicle. My client has been exclusively using this vehicle for whatever period of time. I don't know, I'm not gonna use the word remarriage since they've been married. And we're just asking that she continue to use it, and that this court has the power to do that. I'll pause and let the court, there are some related issues, but I'll wait to be heard on those as well.
Mr. Beglin?
Given the nature of the domestic circumstances, Your Honor, I'm informed, and maybe my client can help the court with facts on just the ownership and use of the vehicle that does not touch on anything inside of the application or the claims made. Because I'm trying to help the court understand the arrangement for that vehicle that does not necessarily touch on anything as far as that's what's charged against him.
If you'd like to, go ahead.
Yes.
And Your Honor, the only thing I'm objecting to about that is that we're already, we're already admitting that the vehicle is in his name. But that is not the court's inquiry here. We're asking that she be allowed to continue to use the vehicle during the pendency of this matter or until it's further modified by another court. So whether or not his name is on the title is not relevant to this court's determination.
Well, I
We're
don't
not
think-
arguing that it's not.
I agree with you.
I agree with you too. I think he's gonna. Can't read his mind, but I think he's gonna tell me that something. No, he uses it all the time, and she used it once a week just to drive to church or something. And that's certainly his ability to put that argument out there.
I'd like
Just
to
because an order
testify.
is extended doesn't mean that the applicant automatically gets
I understand, Your
best
Honor.
choice of everything. There's a need for it, and you're married, so that's going
I
to be part of
understand,
it
Your
too.
Honor, and
So let's give Mr. Baglin the chance to put that forward.
In the home with the 5 adults living there, I'm informed that not everybody was working, and that led to domestic tensions, because adults that don't work, what do you do? To avoid a confrontation, the applicant was using this expedition vehicle.
So it was
Yes,
her.
but
She was
during-
using the vehicle.
During such times that she did,
Okay.
my client was driving the adult daughter's vehicle. That
His-
was how
her
water
adults.
leveled out. He was using that car to go to work every day. She would use her expedition to go to work, do the running around. Now with the exclusion from the home, he is de facto without a car to drive. Now, I don't know, I don't have any details about a Harley, but would it help for you to explain to the judge the circumstances relating?
Would love to.
Please do so.
Your Honor, I bought her oldest daughter, Vicky here, a vehicle to drive. It's not in this paperwork or anything. And when I bought her that vehicle, it left the S10 available. When I bought her that vehicle, they were supposed to sign the S10 over to me. At the same time, I bought a vehicle for me and my wife to drive, her to drive to work, and for us to drive on the weekend, which was the expedition. So I was driving the S10, and now that I'm thrown out of the house, I literally have nothing to drive. She mentions that I have a Harley to drive. Well, I work nights. I don't have any helmet, no gear. I can't drive in the rain and the snow. I literally have nothing to drive. Now I'm on my feet. That's why I'm asking for the expedition, because what I did drive, like I said, was the S10. I have no vehicle now because of that. The motorhome that they're talking about,
Whose name is the S10 in?
the motorhome that they're talking about is also registered and insured in my name, but as they said, it's broken. The tracker that they're talking about is registered in my name. It's not insured. Vicky was driving it and blew up the motor, and that was what I drove back and forth to work every day. When she blew up the motor, that's when we bought her a car, and she gave me the S10 to drive. So now I'm without anything to drive.
May I say something?
All right. Briefly.
We are
Go
willing,
ahead. You're willing to what?
we are willing to sign over the S10 to Charles, or we are willing to sign over the Dodge Ram that hasn't been mentioned to Charles.
The expedition, it's in my name,
Or
it's
his
already
use.
insured.
He has worked on all the vehicles. He knows the mechanical issues with all the vehicles. The motorhome does run. I don't know what's wrong with it. I'm not a mechanic. I don't know what it would take to fix it. He can have the motorhome off of the property to fix it, or we will sign over, like he said, the S10 to him to drive. We just never got that far in the issues at hand.
Well, and it should be mentioned that in this storage locker, this Connex container is a lot of car parts, which at least theoretically could be used, since he knows how to fix, and he's done it in the past, would be used to fix it. So, again, all we're asking is that she continue to use, and he already said it was a vehicle that he bought for the two of them, and that she's been using it. So we're just asking that she be allowed to continue to use it. It sounds like from what Ms. Pena just said, they'll sign over, is it an S10? Is that what it is?
Yes.
The S10. So it's a non-issue, and in my mind, short-term, a non-issue.
And if I may say something else, the only reason I'm asking for the expedition is it is the most reliable, secure, largest vehicle that we have in the family to haul my grandkids.
Does the S10 run?
Yes,
Okay.
and so does the Dodge Ram,
Whose name is the S10 in?
my daughter's.
I can't bind a third party to this, but we can say that it's anticipated the S10 will be signed over to the adverse party, and on a temporary basis, you'll drive the 1999 Expedition. But that's a temporary basis. That's 6 months.
Thank you.
That's That's nothing. That's
Your Honor, when we say sign over, that tends to implicate a legal conclusion or a legal transaction.
they volunteered that.
Well-
That's-
Well, and I
that's
don't
been
think she
made.
understands that by signing over the S10, it doesn't mean that he's signing over the Ford, I mean, I haven't discussed this with her. She's agreeing to sign over, the S10 and does not, understand that the Ford he's not signing over the Ford Expedition.
I'm not making an order.
Thank you.
Gentlemen, I'm
Sorry,
not
Your Honor.
making
I
an order
apologize.
that anybody has to sign anything. I'm simply saying I'm awarding temporary possession of the Expedition.
Perfect. Thank
That's
you.
all I'm doing. And so, ma'am, I can't take comments from the gallery.
My client was trying to make it aware that that's the vehicle, the S10 is purposely registered in a rural county to defeat the smog, because it won't pass smog. And since we're not doing a sign over, there's no change of ownership, we asked the order just reflect that it's temporary exclusive possession at S10 to my client.
Well, I
That's
can't
all.
order in this
Okay.
case.
Well,
It's
can
not
she-
her car.
the applicant can agree.
Alright. So let's get this
Well, she
case
can't
over
agree.
with.
She
So
doesn't own
expedition
it.
to her, 6 months, those terms, and then we can revisit it, okay?
Right. There is another issue, though, which is the issue of the house. We are asking for exclusive possession of the home on Chippewa Avenue.
And that's the protected address.
Yes, Your Honor. That's the address we were speaking about earlier. Just a couple of related issues with the house. Clearly, I'm sure as Mr. Beglin will explain to his client, although all the utilities are listed in Mr. Pena's name, that he's not to interfere with my client's use. There is a past due power bill. My client has received a turn-off notice, and we're asking that half of that be paid by Mr. Pena, because this included the time that the parties were living together. It is for the past due amount is approximately $187. So we're asking that half of that past due amount be paid by Mr. Pena, since she has received a turn-off notice from Nevada Energy. We're obviously asking that he not interfere with the use of the utilities, since they're all in his name. Power, sewer, that kind of thing. Is there a past due sewer also?
I have
No,
no
or is-
access to everything.
That you don't have access?
I have no
Okay.
access, no mail.
Right. That he, obviously, if there's any sewer, which has to be paid, it's not done as part of impound, that he's gonna take care of that. Also, Mr. Beglin, I don't know if he's put in any kind of a change of address, because the mail would be coming to the house. We mailed the notice of appearance to his son's house on Silver Shore, I can't even read my own handwriting, Silver Shore Court, instead. Is he gonna put in a change of address?
No, because he intends to move back into his home at the end of the divorce.
Okay. Anyway, maybe you want to make some kind of arrangements about the mail.
How do you want to get your mail between now and then?
I have the mail being stopped. I'm
Where-
picking up at the post office.
That's the question. Where do you want your mail to be forwarded to? Do you want to put in a change of address form on
No.
a temporary basis? How do you want to receive your mail?
I put in something with the post office where they're holding my mail at the post office and I'm picking it up there.
Okay, so
It's
this
the one in
is,
Golden Valley?
Yes,
this is mail that's only, I assume, in Mr. Pena's name. Is that right, Mr. Beglin?
yes.
Okay, so we would ask that he continue to pay, whatever, obviously the sewer bill is gonna come in his name. He take care of that, he pay one half of the past due energy. And then there's the issue of the ongoing, mortgage payment on the house, and we're asking that they each pay half of it. There's an $881 payment, which includes the impound, and we're asking that that be split between the parties, that they each pay one half of it during the time that the protection order remains in effect.
I paid all myself.
My client can pay it directly to the mortgage company,
Payments all these years.
and we don't have any problem doing that.
And I have.
Your Honor, we'll pay the entire mortgage.
Could you keep quiet, please?
And the
Um,
entire mortgage?
Yes, sir.
You're gonna pay the entire mortgage,
That's correct.
okay? Excuse me, my client had a question. What is it? What do you need access to? Well, you're not. Okay. They've agreed to continue to pay the entire mortgage. And and then my client will be responsible. The problem is, if the only way she could pay any ongoing utilities, since they're in Mr. Pena's name, is if he's going to forward them to council, because he's having his mail held. So Nevada energy bill comes, and it's gonna be held. So does council wanna provide it? I mean, how are we gonna do this?
I don't know how long, I'll say it this way. Simple matter, doesn't have to be this complicated, but if my client receives if you get a utility bill for the house, get it to me, and I'll mail it to her lawyer so it can be paid.
Sure.
Fair enough. How's that?
Okay, does that work, Teresa?
Yes, ma'am.
Okay, so there's electric, is there gas, electric, gas?
Mortgage, power, sewer, water, internet.
Yeah, no, they're gonna pay the sewer. We're not gonna pay the sewer, but we'll pay the electric, the gas. You have your own cell phone?
Yes, ma'am.
Okay. And then if there's any, is there cable? Is there cable or internet
There's the internet,
that comes in his name?
yes.
Okay, and then he'll forward the internet bill as well.
So utilities to me.
All right, anything else, Mr. Bagley?
Your Honor, just as I indicated before, I wanted to make the record clear that we do oppose any extension. We understand the rationale why, and that if called to testify, my client would invoke his right to remain silent. He does have a computer and monitor. Both parties have their own computers. He would like his, please. And he wants to help the court clarify, or maybe have him understand what's with the expedition. So with the computer aside,
Well, I've made my decision on the expedition, all
Okay.
right? The decision had to be made, all right? So he wants his computer back. Do you know what he's talking about? That he wants his
Do
computer
you know
back?
where his
Yeah.
computer is? Yes, sir,
On his desk.
on his desk.
And so
Okay.
she'll provide that for you, sir. And your counsel can work that out with opposing counsel.
Yes, Your
when you
Honor.
come pick that up. He needs to have that, okay?
my client's just, despite we understand what the court said, he's telling me that now he will not have a vehicle to get to work. So,
I have nothing. I have nothing to drive. They have 4 vehicles with the expedition. I have nothing. And that's not counting my son's car that he lives there too, so with that, there's 5 vehicles there that run. I have nothing.
Well, it sounds like they offer to provide the S10,
The Chevy S10.
yeah.
And also the motorhome runs that he can have.
So there sounds like there's a couple. We're not going to go into this here. I will tell you this: when somebody has been charged with domestic violence, the court will do what they can civilly to make it equitable and fair, taking into consideration what we have. But sometimes you can't split things in half. I can't give you half the expedition. I can't give her half the expedition. It's on a temporary basis, and it sounds like there's some other options for you. Okay? Just because it's not as easy as you would like or she would like, I apologize. You've come to the court asking for the court's help, in a sense. And so if that's not convenient for you, well, that's just the way that goes. But I will put it out there that it sounds like they're willing to work with you on the S10.
Yes, Your Honor.
This is a temporary order. It's 6 months anyway. And once the divorce, well, I don't even know what to call that. Once the divorce is discovered, if there is actually a divorce or not,
Really?
that's going to be interesting. I will be following that case.
we're
certainly.
perplexed whether we can do a notice of set and get that case, or just do what the law clerk asked way back when.
Or whether latches,
And then would it be
Yeah.
then nunc pro tunc back to 1997?
or whether there's latch, it's weird
Yeah.
about
Right.
latches too.
I don't know.
I don't know.
So that will be the order. We'll give him a copy of the order in person, certainly, for this case. We'll have the next case called. Mr. Mlick, you're certainly free to go. We'll file the
Right.
order electronically. You'll have access to.
And you do know that her daughter's case is on the docket as well.
I do.
Okay, thank you.
You're welcome.
Should we remain, Your Honor, if that's the next
Absolutely.
one?
Yeah.
And I'll just have her come to